Hello everyone, I'm Nazarat Fatima and you're watching LiveLaw. As you know, the hearing in the Article 370 matter is going on and the abrogation of the article has been challenged on various grounds. We have created a series of videos on the arguments made by senior advocates, namely Mr. Kapil Sibal, Mr. Gopal Subramaniam, Mr. Zafar Shah, Mr. Rajiv Dhawan, Mr. Dushyant Dave and Mr. Chandaroday Singh. Today in this video, we'll discuss the arguments made by senior advocate Dinesh Dviwedi, senior advocate Sanjay Parekh and senior advocate PC Sen. To remind the viewers, a constitutional bench comprising CJI D.Y. Chandrachud, Justices Sanjay Kishan Kaul, Sanjeev Khanna, B.R. Gawai and Suryakant is hearing the matter presently. Mr. Dviwedi started with arguing that the accession of J&K with India was different from that of the other states as J&K never signed a standstill agreement and it acceded with India after August 15, 1947. While on the other hand, other princely states ceded all their sovereignty in an unqualified manner with India by signing the standstill agreement, which was a precondition to the accession. He then stated that J&K acceded to India as a Part B state like all the other princely states. He argued that Article 238, which dealt with the application of provisions of Part 6 to states, was made applicable to only Part B states. Mr. Dviwedi highlighted that Article 238 keeps the promise of applying the Constitution of the state to the Constitution of India and was required for all Indian states to merge unconditionally into India. However, Article 238 was excluded in its application to J&K and was never made applicable to the state. He asserted, and I quote, "That speaks volumes about the autonomy of the state. Our basic theme is that Kashmir was different. Kashmir was different both in terms of accession to Dominion of India, where it ceded at a different time as an independent state or a nation. And it was different in the sense that it did not merge unlike the other states. The conditions added in favor of Kashmir that we are not bound by the constitution or the future constitution. The internal sovereignty rests with the ruler. The Union of India cannot acquire land in Kashmir. These were different." He then stated that sovereignty was retained by the Raja of Kashmir in the instrument of accession. In this context, he said that the idea of sovereignty was a variable concept and consisted of two factors, internal and external. And thus, just because a state may have ceded external sovereignty, which included defense, external affairs and communications, it did not amount to ceding of internal sovereignty as well. Continuing this line of argumentation, he said that Kashmir did not lose all internal sovereignty just because it acceded. His next line of argument was that Article 370 ceased to operate once the J&K Constitution was enacted, and accordingly all the powers conferred under Article 370 to abrogate it also ceased to operate when the J&K Constitution was made. In this context, he stated that it was important to keep in mind the object of Article 370 and the commitments made. He said, and I quote, "We always say that our framers were very wise, but when it comes to the commitments they made, we forget it." He also referred to a speech of Dr. Gopalaswamy Iyengar made during the Constituent Assembly debates. Referring to Article 370 as an interim arrangement, he said that the final decision with regard to the jurisdiction of the Union and the Indian Parliament over Kashmir as well as the centre and state relations was always meant to be taken by the Constituent Assembly. Still referring to Dr. Iyengar's speech, he stated that at the time of formation of Article 370, neither the Constituent Assembly nor the State Legislative Assembly for J&K had existed. Thus, the constitution makers were forced to consult the government till the Constituent Assembly of J&K was formed. In addition to this, he referred to Constituent Assembly as the most august assembly with men who fully knew what constitution means. Mr. Dviwedi asserted that when they say Kashmir should frame their own constitution, they could not have implied anything else. At this juncture, the CJI expressed his reservations, accepting that the speech by Dr. Iyengar represented the whole country's commitment to J&K. He asked, and I quote, "Can we say that a speech made by an individual member of the Constituent Assembly, however weighty, represents a commitment by the nation to J&K? This would have a bearing on the interpretation of Constitution." Mr. Dviwedi responded to the same by stating that the country's thinking, which it had been tuned to follow for the last 70 years, was one nation, one constitution, but the same was nowhere prescribed. He added, and I quote, "I'm not here to judge whether they were right or not. I'm telling you what intent can be culled out from the debates. We may not like it, but all I'm showing is the intent. And can Article 370 be divorced from the intent?" In continuation of this argument, there was an interjection from Justice Kaul, and even the CJI underlined certain consequences. To know about those, please visit the article shared as a link in the description box. The arguments were followed by senior advocate Sanjay Parekh, who said that written constitution is supreme. He contended that the people of Kashmir had come together and given themselves a manifesto, as per which they wanted a constitution and an economic plan for Kashmir. He added that the sovereignty of J&K rested with the people and they expressed their sovereignty in a specific way. He added that this sovereignty was translated to J&K constitution. Meanwhile, he said, and I quote, "When there is a written constitution, the written constitution becomes supreme." Moreover, Mr. Parikh also highlighted that Article 357 was never adopted for J&K, and the implication of the same was that Indian Parliament could not assume to itself the power of the state legislature to enact law and could not further delegate it to the President. He also stated that the recommendation of the Constituent Assembly was interchanged by recommendation of the Parliament, and this meant that something which could not have been done directly was done indirectly. And then senior advocate PC Sen started his arguments. He started with arguing that the Constitution of India is anti-majoritarianism. Mr. Sen framed his arguments under three broad heads: historical, jurisprudential, and in terms of constitutional ethos. Talking about the historical context, Mr. Sen submitted that the J&K region consisted of a Muslim majority. He said that its population had a choice between going into Pakistan and being a majority or staying in India to be a minority. They chose the latter and made a conscious choice to remain a minority in a region in the backdrop of horrific violence of partition. He stated that in this backdrop, if there is a constitutional promise in nature of Article 370, the same should be strictly construed. He contended and said, when there is a conscious choice made in this manner, it is all the more reason to strictly construe. He also argued on jurisprudence and the constitutional ethos and submitted that asymmetrical federalism as under the Constitution is provided for protection against majoritarianism. He asserted that our Constitution is also anti-majoritarianism. In this context, he stated that the moment there was a fundamental constitutional principle, there must also be a limit. While talking about anti-majoritarian rights, he also highlighted LGBTQ+ judgments and how there was a devolution taking place. He added, and I quote, "If one were to do away with this thing which involves historically a religious minority, that would be a regressive step." Finally, he argued that as per material that already existed on record, J&K ranked higher than other states when it came to peace, security, effective governance based on rule of law, and upholding principles of equality. And thus, there was no reason to impose Article 356 in Jammu and Kashmir. That's all about it for now. We hope you like our content. If you do, please like and share. Also, subscribe to our channel on YouTube. And don't forget to press the bell icon for notifications. Thank you for watching.